Hello, and welcome to this training on personal protection orders, clients with high barriers. We're so excited to share with you today and for you all to learn. Though you're just going to be listening to voices in this training, we encourage you to lean in and participate and take good notes and really take something away from today's discussion. My name is Brittany Kellum. I am the trauma program manager at the Survivor Law Clinic, but of course, I work in the Michigan Coalition to End Domestic and Sexual Violence, and I have two colleagues with me who will introduce themselves.
Hi, I'm Kate Dold. I'm one of the staff attorneys in the Survivor Law Clinic.
Hi, I'm Becca Zaris. I'm the other staff attorney in the Survivor Law Clinic.
We're going to start by telling you that this project, the information that we're sharing with you today, is supported by a grant that's awarded by the Office for Victims of Crimes and also the U.S. Department of Justice. And we are the authors of the information. They don't share our same opinions or findings or conclusions. So just keep in the back of your mind that the thoughts and perspectives and learnings that you'll be given today come from the coalition.
This training is not legal advice, and we are not advocating for practicing law without a license. It is illegal to practice law without a license in any jurisdiction. We hope that this information can be used by you and your organizations to better inform survivors about the legal process and their legal rights.
This information that you are going to hear and see today is so important to our work and our roles and your roles as leaders and thought makers and decision makers, but also to the work of advocacy. We work in a movement where survivors, people are harmed, and with that harm, we know comes a lot of trauma, and the trauma causes a loss of safety and control. We are working with people on their worst day. We're working with folks that often don't know how to navigate systems, and so they're having to do things for the very first time. This is especially true within the legal system. And so today we're going to be exploring safeguards for survivors with high barriers. That means we're going to be looking at a specific tool, a PPO, personal protection order, and how that tool impacts folks with given identities, specifically children and Black women. So survivors can use a variety of things to feel protected or enhance their safety. And again, a personal protection order is one of those tools that can be used to minimize threats, harassment, and violence. So when we think about the work that we do with survivors, the work that is required to do for survivors, one of the things that we think about first is intersectionality, right? What does it look like to be intersectional with clients? What does it mean when we are even using the word intersectional? And what this means is folks come with a variety of identities. It's not just their ethnicity, it's not just their education, it's not just what brings them into our office, our agency or organization. It is their whole lived history from the time that they were born up until now, their daily experiences, their family history, their religious affiliation, the community that they're coming from. So when we're working with people, we are responsible for working with a person as all of those identities come together. There's not one that we're paying attention to more. There's not one that we're leaving out. So in this case, as I mentioned before, when we think of intersectionality, we're thinking of perhaps young people who already have a certain amount of challenge because of how they have to navigate the world, but particularly in the legal system, because they are youth aged, right? Because we could be talking about clients that are, depending on who your organization serves, we're talking about minors as well as children that are possibly in their teens. You are thinking about what hardships that are specific to age. You're also thinking about those hardships again against what's already existing in the legal system. And their families, their social life. What type of supports is this person going to need as a whole person? Conversely, another example that I could give is how Black women, Black clients have to navigate the space of personal protection orders as it pertains to their identity. We have two identities here, their ethnicity being Black and then also being a woman. What does that look like in the context of legal advocacy? What does that look like when they're having to petition for protection? What does it look like when they're having to navigate working with an attorney? And so the work of intersectionality means that you are looking at the person with a full lens of appreciation and compassion and willing to work with them with empathy as well. When we think about the term trauma informed, it's important for us as advocates to be aware that we must know as much as possible about trauma. We have to know how it affects people. That I mentioned earlier that we're often working with people on their worst day, which means that when they come in and they're angry or they're feeling like they don't want to participate, it's not something that we're necessarily doing, though we do need to do our best job to be professional and be welcoming. But it's the nature of trauma. It can be a response because of this horrific incident that they've experienced. And so we have to be cognizant of that, not just aware at like a foundational level, but really working to build depth in our understanding of the variety of trauma responses and how they might look in our individual roles when we're serving clients. It means that we also know that we're not othering the people that we serve. A lot of us can think of trauma that we all have experienced together, like a pandemic, like political situations, um, organizational changes also can result in trauma. And so we're not that far away from the clients that we serve. And so it's important to keep that in mind so that we're not providing a stigma or an additional barrier on top of the identities that folks come in to our spaces with. And then lastly, talking about survivor-centered. It doesn't just mean that we are keeping survivors in mind. That sounds nice, but in practice, that means that we're really meeting the needs of the individual. So many times, particularly in the space of sexual violence or domestic violence, we really can feel like we've seen it all. And I'm here to tell you that there's always going to be a case that's going to be different and challenge you and is going to bring a variety to what you might consider the mundane caseload of survivor work. And so when we're being survivor-centered, that means that we're working with the individual, that we're appreciating their uniqueness and we're serving them depending on their circumstances and not what we've done 5 minutes before, not what we've done with this particular client before. And so particularly, I want you all to keep in mind that when we're talking about survivorship, when we're talking about personal protection orders, when we're talking about this advocacy work, you want to keep intersectionality, trauma-informed work, and survivor-centeredness in your mind because we're going to see how clients have to navigate these barriers between these guidelines, how they come together to create high barriers specifically for children and folks belonging to Black communities.
And how advocates like you and keeping all those tenets in mind can help prepare survivors for the realistic interactions they're going to have when they encounter these systems.
Absolutely. And in line with what Becca just said about being realistic, a part of that is we live in a society and a culture that has had several traumas, several groups, several communities have had experiences that have caused earnestly perspectives and treatment to be different for them. And so here we want to talk a little bit about not in an exhausted way, but historical traumas and legal advocacy. So I mentioned Black communities, for Black women specifically and young Black girls, because of experiences of racism and because of experiences of discrimination, there could be an invisibility that moves into the space while navigating personal protection orders. There have been instances of dehumanizing and devaluing when even talking about an experience could be ignored or underappreciated. And so when we talk about violence, we could then argue that it will be harder for the supports, the systems that are supposed to support Black women and Black girls to actually provide advocacy or good advocacy because there's this foundation because of systemic reasons of disbelief and invisibility. There's not often representation for this community, and therefore it could be harder to imagine what violence looks like within this community. Instead of, as I mentioned before, appreciating that this is a survivor, trauma has occurred, so it's important for us to be trauma informed and survivor centered. Also, what happens with personal protection orders is you have to tell on someone. You have to disclose that someone is the perpetrator and identify that you are the victim. So we have this concept of racial loyalty. We know that there's disproportional contact with law enforcement and Black communities. So this means that if someone is having to defend their safety, right, find support for an experience that they've had, they might have to tell on someone that is within their community. So this is a hardship. This is the reality of I want to be helped, but also I'm now having to be concerned for a possible perpetrator's well-being. So this is what we mean by racial loyalty. And then when we think of stereotyping, two stereotypes that might not be familiar in name, but might be familiar in the description are the mammy and sapphire stereotype. So historically on plantations, the mammy is the caregiver. The mammy is someone that has kept information close and is often like the executive assistant, but oftentimes also has extreme trauma and violence that's exacted upon her. The mammy is also someone who is often unattractive and is almost believed to be asexual, but then there's this juxtaposition as someone who is regularly sexually assaulted and not able to child rear her own children, but helps to raise and rear the plantation owner, in this example's children. So how we see this now in present times, because I don't want us to just to couch things into like this box, right? Is some of our clients might come bearing a load where it could appear that they don't want assistance or they're being stubborn to the support that we're offering. And it is because of this stereotype, this intergenerational trauma, where we see this come alive. So this means that we have to press in our advocacy and realize that, oh, this is because now I have this context for how they could be seeing the world. How could I be creative about working alongside this population so they can actually have access to help and not have the barrier? And this is also why it's important that we not use terms in the legal sphere or at all in calling our clients, oh, you're really strong. Because again, it plays into this strong Black narrative where folks are actually just doing what they need to do to be able to survive and receive support. The other stereotype that I mentioned is sapphire. Sapphire is this fiery, almost temptress, like high sexual drive, but very emasculating and feisty verbally. We think of the stereotypical neck rolling and talking with hands or talking loud, and these clients often have a hard time navigating legal spaces or spaces of support in general, when really if you remember, we talked about trauma responses. Everyone has a right to be angry, frustrated, and express deep emotion in relation to something horrible that has happened. And so in this way, we understand that the sapphire is a misnomer. It should not be used for this community because it often results in the perception of hostility. It results in a lack of receiving support. It results in other people being called into the space, more interaction with law enforcement because of the perceived hostility that's incorrect. And so when we're thinking about personal protection orders, it means that we have to have a gentleness, again, the importance of being trauma informed and be able to defend our clients as we're helping them to navigate the legal system, navigate this part of legal advocacy. It also means that as good advocates, we are being aware of blind spots for our clients, and we're able to be good allies and provide support. And we're a part of a system. Though we're helping, we're a part of a faulty system that could serve as a systemic barrier for clients in communities that are already used to having systemic barriers. So we have to be not only mindful of that, but create ways that we can push against and open up the gates of help instead of being gatekeepers. So what I have seen in the clinic is to mitigate some of the barriers like work-related absences and loss of income are allowing clients when they do arrive to take the time to do the work of the PPO with the attorney or with the advocate. You can limit the amount of visits that someone has to have to your office, that someone is really uprooting their life, which causes more trauma, by using the time that you have more wisely and by allowing more time if you have to walk through the steps so that you can acclimate them to the relationship they're going to have with you, but also so that they can get to know you, but also get to know the process that they're about to embark on. So you want to be mindful that repeated trips require for a PPO filings make someone have a need for childcare. And again, they increase re-traumatization. So thinking about things that you can do to decrease these things, to decrease these barriers for the clients that we serve. So we know in the context of children, also continuing to think about barriers, is that 1 in 4 girls and 1 in 13 boys experience sexual abuse. That's a high number. And we also know that many children wait to report or never report child sexual abuse. Therefore, the numbers are actually below and don't truly demonstrate the impact of the problem. And in 2022, 76% of children victimized were by a parent or legal guardian. We raise this because children are oftentimes supervised by adults and therefore need some sort of adult assistance because they're minors still and trying to navigate the world. And so if you can imagine for the context of a child, I'm having to report and talk about violence that quite often is going to mean that the perpetrator or the person that I am discussing in this protection order is going to be someone that was close to me. And it's not just violence that happens within families. We also know that children experience violence, and teens specifically, amongst each other. And so 1 in 3 teens in the US are a victim of teen dating violence. That's physical, sexual, emotional, or verbal abuse. And this is from a dating partner. It's important to also acknowledge that adults aren't the only folks that can be stalked. Young people are also experiencing stalking, and it's a common type of teen dating violence. So we want to keep this in mind when we think about children and their rights and their voice. Children oftentimes do find themselves in positions to navigate the legal sphere by needing a PPO. So it's important to give children voice, explain, and keeping in mind developmentally what they might need, so that while you're advocating for them, you are also meeting them at their developmental need, but meeting them as a survivor with the same respect and regard as you would another client.
It's important to know whether a minor can file for a PPO. I think we tend to think of children as perhaps unable to do that. And the truth is they can, but there are some caveats to it. A minor, when they're petitioning for a PPO, must proceed through what's called a next friend. A next friend is a trusted adult. Could be anyone, could be someone from church, could be someone from school, could be an older relative, sibling. It just has to be someone over 18. But we know this is another barrier because depending on who the perpetrator is, might dictate who'd be willing to be an ex-friend. Maybe there's no one. Brittany just discussed many children experience violence at the hands of a parent or a legal guardian. Minors cannot petition for a PBO against their biological parent unless they've been legally emancipated. So what does that mean for getting safety? Do we need to access other systems are they willing to access these other systems like law enforcement, or is CPS involved? Those are just things to think about in the context of whether or not a PPO is appropriate. Respondents can be other minors, but that comes with special caveats too, like different forms and different service, which we'll discuss later. A respondent cannot be younger than 10 years old, though.
Oh, children still, youth and teens. We talked a little bit about statistics and prevalence of violence, but we also know we need to think about what it means for a young person to actually move forward with a personal protection order. We know that youth are some of, if not the most vulnerable crime victims, and due to their consistent need of adult supervision, as I mentioned before, um, perpetrators can easily manipulate getting access to children. And that means that children are dependent on these adults. And so this situation makes for young people having high barriers in reporting access and expressing their assault. And so we look at loss of caregiver. Young people could either have an experience where they have physically lost a caregiver in the experience of violence, or there's a loss of caregiver because they actually still love and care about the person that has caused them harm. So it's something to be mindful in the reporting process, in your conversations and meetings with your client, that they could be experiencing really and real feelings of regret and sadness because they're having to perpetrate, or they're having to report, excuse me, against someone that has perpetrated um, against them, but someone that is also close to them. And then when we think about the non-offending caregiver, there could be worry and concern for that person's well-being. What we know is if a child experiences abuse, particularly in a home environment, and likely by someone that is close to them again, it is hard to imagine that the non-offending caregiver did not experience some level of harm or violence. So we also want to keep in mind that there's an impact of disclosure on others for young people. They might be responsible for other people's feelings, and how even telling how that will affect their family environment. And this is also important to think about when we think about like the familial context. There could be unstable relationships within the family that's already contextualized or characterized by violence. And so as advocates, we want to be mindful of that and how we're approaching that. When we think about a struggle to differentiate appropriate touch, developmentally speaking, some children might not have the language for their bodies, let alone the language for violence that occurs to their body. And this means that they might not then be able to recognize what happened to them as abuse. This also means that on top of that, they could be limited in their understanding of the legal process and their knowledge about how it means to put that into the context of a personal protection order. So again, that goes back to taking a moment to restructure your office, even that to make it be more child or youth friendly, restructure your process on how you're approaching filing or going through a PPO so that it fits the young person. There are a lot of feelings that young people have in general, right? But particularly when they've experienced violence. And we also have to be cognizant of that youth blame themselves or could downplay the severity. So as you're doing your meeting for a personal protection order with, or conducting your meeting for a personal protection order with a young person, having them explain it a couple different ways so that you can really get a sense of what happened and making sure that that's demonstrated in the PPO. There could be feelings of shame, embarrassment, guilt, and sadness. And sometimes, unfortunately, that does outweigh the possible positive outcome of a successful PPO. That's something that we have to be okay with. If a young person decides, hey, I don't want to do this anymore, I'm very uncomfortable. It's also something that could provide an opportunity for you to provide more education about the possible court proceedings, what the specific process of their PPO could be, what they could expect, because people are oftentimes empowered with information, and it's a part of you building trust, of having those conversations with a young client of what to expect. And I also think of this protective coping as I'm thinking about other struggles and emotions that children might go through. There it could look like they don't want to participate, right? You could be sitting in front of a kid and they're ignoring you, or they're avoiding having conversations with you. It's just really hard to get the young person on the phone or in your office. And just be mindful that these avoidant techniques are symptoms of trauma. They are responses to what has happened to them. And they could very well really want to participate in this process. And they could have really connected with the attorney or the legal advocate. But we're having to dig deeper as advocates to override, and how we really make sure that that rapport and relationship has good foundation, so that we could carry them through these circumstances. Yes, they are in the driver's seat, but sometimes we have to carry our survivors through emotional hardships. And there's a fine line, but carry them through emotional hardships so that they can meet the goal that they have with you. And when I think of Tattletale and the Snitch, right, it sounds like a children's book, but it's not. It's the realization that children's social environment is very important to them. And if they're navigating a space where they're disclosing violence that a peer or someone in their school or educational environment has caused, it could mean that they are walking around with these labels that they've told on someone. And then besides that their social network, their social environment has changed dramatically because they're having to report this violence. So lastly, I just want to say that as advocates, also think of the cultural and societal norms that children are faced with, and systemic restraints. They could have prior perceptions of law enforcement and the criminal justice system. They could have already navigated child welfare services. So there might not be a lot of faith for their concern and confidentiality that a process like a personal protection order poses. And they could be afraid of losing control. We live in a society, unfortunately, that has a lot of invisibility of sexual abuse and violence as it relates to youth. Just now we're starting to come around to some of those conversations in really efficient ways, but we still have a culture of blame and discouraging the youth voice. So think carefully in your agencies and in your work. How can you uplift the youth voice in general, but also specifically as they're approaching PPOs? How can you make this an experience where they feel triumphant, and when they're learning independence and autonomy, but also learning how to trust? Because young people more than ever are really connecting these concepts for the first time. And our adult clients can feel this too, but specifically we have an opportunity to impact their development in positive ways and diminish harm, or decrease harm, if and wherever possible.
And so keeping in mind what youth and minors, might be experiencing or thinking about when they're reacting and dealing with the violence or threats of violence. We also want to make sure as advocates that we have a shared understanding of what a PPO is so that we can inform our clients. And again, being survivor centered, giving them the option so that they can make the informed choice that works for them. I like what Brittany was saying, and it made me think, when I'm meeting with a minor client, maybe for the first time, letting them know, the relationship between me and them, me as their attorney, that they really are the boss and they're going to tell me what they want to do. So after talking about, different types of PPOs, they might say, "Oh, I don't think I want to go through with this process." And I am there to say, "Okay, that's your choice. And so, we're not going to go through with filing. Or maybe they'll think, yes, after you told me what I can expect, I do want to file. In Michigan, a personal protection order is what the restraining order is called. It might be called something else in different states, but I'm going to be referring to it as a PPO throughout most of this presentation. A PPO, it's a court order to stop threats or violence made against you. So a PPO can help protect you from someone who's threatening, hurting, or harassing you, or even stalking you. And you can get a PPO if you have reasonable fear for your personal safety. A great resource in Michigan is michiganlegalhelp.org. They have a few articles on the overviews of a PPO and even a PPO help tool where a survivor can fill in the information and it will generate the necessary court forms that they would need to file for a PPO. In Michigan, there are three kinds of PPOs per statute. There's the domestic relationship PPO, which is a lower burden of proof. There must be a domestic relationship, which we'll go into on another slide. There is a second statute that includes stalking and sexual assault. So both of these petitions require a higher burden of proof. For stalking, there has to be two non-consenting contacts, and that cause reasonable fear. And then for a sexual assault, we'll go into this on another slide as well, but it's going to restrain non intimate partners. So if there was a sexual assault by an intimate partner, we would advise, filing for a domestic PPO because again, there's that lower burden of proof. But for non-intimate partners, a sexual assault petition would be the one they'd want to file. If someone is convicted of a sexual assault, the court must grant the PPO. The court does not get discretion on that issue. The sexual assault statute also contains rape shield protections. So that will protect a survivor's past or maybe current sexual activity from coming into the case as evidence unless the respondent is using it to say the survivor was consenting or that someone else committed the sexual assault. So it is important that the survivor is aware of what information could come into the court case by the other party. In terms of general filing requirements, for the different petitions, there's different court forms, but on a petition, the survivor is going to have to write out the incidents or threats of violence that occurred. So this is the who, what, and when. And you want to have enough detail that a judge can read it and understand why the survivor is fearful. A survivor can also request that their address be listed as confidential on the PPO. That is done by filing a separate court form with the court. And then some courts may require the survivor to have the respondent's address on the petition before filing. It just kind of depends on the jurisdiction, but that is unfortunately another barrier that we see survivors face. I talked a little bit about domestic PPOs already, but for domestic relationship PPO, you're going to have to list out what the relationship is. So this could be a spouse or a former spouse. It can be someone who is in a dating relationship, but it also can be a cohabitant. So that is a roommate, whether it's current or former. There needn't be a dating relationship involved. It can also be with someone that you share, a child with. And then the second element is evidence that there's reasonable cause to think that respondent may commit one of the prohibited acts listed in the statute. And a barrier I hear survivors facing is they will say, I don't have evidence to prove that this person did this to me. I don't have texts, I don't have a call log from on my phone. But we like to tell survivors that they are the best evidence because in determining this reasonable cause, the court um, is going to consider a survivor's testimony. So perpetrators, they know how to not get caught. They might not be threatening through text messages. They might be doing it in person. So if a survivor can testify about that in court, then that is enough evidence to get a PPO. The court is also going to consider a respondent's past behavior. So if the respondent has threatened to commit one of the prohibited acts in the statute or has actually done one of those things, then that's something that the judge is going to consider as well. So that's why it's important to create a rapport and trust with your client so that they feel comfortable telling you about what has happened to them. They might only be coming to you, about the most recent incident, but you should be asking them, if there's been past incidents, and as Kate has mentioned, whether they're comfortable putting that in the petition. Maybe the petition's strong enough with just one incident, and they don't need to bring in the other incidents. But filing a PPO is essentially starting a lawsuit with somebody else, and so the survivor should just be aware that the other party can and is likely to bring forth other information. So there might not be a guarantee of keeping certain things out.
As Becca mentioned earlier, our statutes provide for a non-domestic stalking PPO. The respondent is is someone who the petitioner does not have a relationship with. And so, as the slide says, you don't need the evidence of a relationship like you do with a domestic. In practice, non-domestic stalking PPOs they might be the most difficult to get. Judges are really looking for a pattern, and typically the contacts must be more than just annoying or frustrating. Judges tend to like to see some threatening behavior. They want to see at least two non-consented contacts. That's the pattern. And they're looking to see that a reasonable person would feel terrorized and frightened, intimidated, threatened, harassed, or molested. And this reasonable person standard is a really big barrier in terms of obtaining this petition because stalking can be very nuanced. And so explaining why a reasonable person would feel terrorized um, in behaviors that might seem sort of innocuous is the goal of writing a successful petition. And then you also have to prove that the petitioner actually felt the things that are like terrorized, frightened, intimidated, threatened. And so that involves the survivor expressing these emotions in the courtroom, which can be difficult and presents another barrier towards getting this type of PPO.
And then there is a statute for non-domestic sexual assault PPOs. And this requires that judges will grant a PPO when a respondent has been convicted of a sexual assault of the petitioner. So if they were convicted of a sexual assault against someone else, a different person, unfortunately, that section of the statute doesn't apply. But the survivor could still petition because this PPO can be granted if the respondent gave a minor obscene material, or if they subjected, or threatened, or placed in reasonable apprehension the survivor of sexual assault. And so relief may be sought and granted under this subdivision, regardless of whether the perpetrator was charged or convicted of a sexual assault by a prosecutor. Uh, but it's important to note that with the non-domestic sexual assault PPOs, this process is often happening before a criminal case can be started by the local prosecutor. Police investigations, prosecutor review, at least in our jurisdiction, usually takes a few months up to a year. So in the meantime, the survivor might want protection while that criminal case or criminal investigation is pending. And so clients should consider how a PPO might affect a potential criminal investigation and prosecution. So if a survivor testifies at a PPO hearing, technically that transcript could be used in a criminal case by a defense attorney trying to say the survivor has changed up their story or the survivor, is lying about something. Uh, we've often seen that respondents in a sexual assault PPO case have hired a defense attorney. And if in the future the prosecutor brings a criminal case against that respondent, the respondent might hire the same defense attorney. So the PPO case might be an opportunity for that defense attorney to try and get some testimony out of the survivor, maybe, some details that the survivor might not otherwise want out there. So it's just important for a survivor to understand the risks that can come with filing for a PPO before the criminal case. But it's just help. It can be helpful for them to consult with an attorney if possible.
PPOs must on there, the order that when the PPO is granted, the order that comes must list an end date. It's at the bottom, just a little bit above where the judge has signed. If the PPO is granted ex parte, which means without a hearing, it must be at least for 182 days. But in practice, judges tend to grant PPOs for a year period, a year from the day it's granted. So that might not be the same day that it was filed. There's actually no statutory limit on how long a PPO could be granted for. So sometimes, for example, in cases with non-domestic sexual assault, PPOs where there's been a sexual assault conviction, and that could be for any of the CSCs. Um, a survivor might ask for a longer period, maybe 5 years, so that they don't have to keep going back every year and asking for a PPO that is mandatory for the court to grant. Um, Petitioners may also file what's called a motion to extend and ask the court to extend their PPO. This has to be filed per the court rules 3 days before the expiration date. However, in practice, it's a good tip to file at least a couple weeks before the original PPO is set to expire. And it's really important in your motion to extend to focus on behaviors that have happened while the PPO was in place. It's difficult sometimes to convince a judge that you need the PPO extended if the respondent has abided by it in that year or whatever long period the original PPO was granted for. So focusing on the potential for continued contact and things that might have happened while the PPO was in place and the fear are good things for a motion to extend.
And so another barrier, unfortunately, in this process is the service. So it's important to note that failure to serve a respondent with a PPO does not affect the validity of that PPO. So as soon as the judge signs the PPO order, that PPO is in effect. It is sent from the court to law enforcement to put into lien, which is the law enforcement information network. But what could happen is if, let's say, a PPO is put in place, the survivor is at work, the respondent shows up to their work and is harassing them. Survivor calls the police. If the police are responding, the respondent could argue, "Oh, I wasn't aware that there was a PPO that said I couldn't come here." Police who are responding to post PPO issuance and pre-service calls, they are supposed to serve uh, the respondent verbally with the PPO. And then the police should file a proof of service of that oral service and file it with the court. But the police can still arrest the respondent if there's probable cause to believe a crime has taken place. If the respondent's not engaging in criminal behavior when the police arrive, their first response is likely to just be a warning and telling the respondent, well, now you know the PPO is in place, so you have to leave the premises. Then service has to be personally made. And so that can be done in a few ways. It could be personally, like by one person giving it to the respondent, handing it to the respondent. This could be by a friend or a relative of the survivor if it's safe enough. We often will employ a professional process server or our local sheriff. Uh, Service cannot be made by the petitioner themselves. Local process servers and sheriffs are allowed to charge a fee. That fee is allowed by statute. They're not supposed to charge exorbitant fees, but we see it happen sometimes, unfortunately. So that can be another barrier. Service can also be done on an adult by registered or certified mail with a return receipt requested. That's that little green paper that the post office offers. And then it has to be delivery restricted to the last known address of the respondent. If the respondent is a minor, the statute and court rules require that the minor be served with the paperwork as well as their parent or guardian, if the address of the parent or guardian is known. And then post service, it's important to file a proof of service with the court after that PPO is served on the respondent. Because the court will take that proof of service, give it to law enforcement, who will enter that into lien. And so, if we go back to that example I gave earlier, if the respondent was served, but then showed up at the survivor's work, survivor called the police, when they responded, could arrest the respondent on the spot because there would be proof in their system that a PPO was in place and the respondent was served with it. So I do advise clients to keep copies of their PPO as well as a proof of service. I advise them to keep one at their house, keep one in their car or in their bag, just so that they can show the police if they need to that those documents, are in place. Oh, I did want to talk about a barrier there with minors. It's all well and good if I can give the PPO to their parent, but what happens when the minor's at school? So that just might be something that we have to talk about. Maybe the minor survivor could keep the PPO in a folder and keep it in their backpack. Or if, the minor and the parent are willing, maybe they should let the school know that the PPO is in place. But there might be a reason they don't want the school to know. So it's just a matter of, talking that through with the client and their parents if they're a minor.
As executive directors and leaders of DV and SA organizations, it's important to understand who can help a survivor file a PPO because, getting down to a court can be a very difficult situation for, adults, also for children. And so we're lucky in Michigan that we have a statute that allows advocates to assist with this process. And the information on the statute is here. Advocates are allowed to provide legal information to survivors. They can tell them what types of PPOs are available, what kinds of incidents can go into a PPO. They can assist them with writing out the incidences. What they can't do is offer legal advice. There's a difference between legal information and legal advice. Legal advice is solely provided by lawyers. This means legal interpretation of the PPO statutes, completing paperwork on their behalf and signing their own name, um, and going into court and speaking on behalf of the survivor. And it's really just important to, maximize um, the use of advocates in this process because local advocates are in a very unique position to kind of learn and be aware of local court processes and judges. And this can be really helpful information to a survivor. They can kind of tell a survivor what to expect. And that's one really important aspect of being trauma informed, and also survivor centered because I want to tell a client, what they can expect to the best of my ability so that they can use that in making their decision of what they want to do going forward.
Yeah, and to Kate's point about the importance of advocates, we've had a lot of cases where the advocates have helped the survivor file the petition, get the PPO in place, and then the respondent has filed a motion to terminate, and now there's a hearing. So at that hearing, that's when maybe we can sign a retainer with that survivor and accompany them to that court hearing and help prepare them for that. But our local advocates are really a big help in this. But now we wanted to talk about what it looks like to assist a minor with obtaining a PPO and how barriers to accessing the court's protection can appear for minors and what we do at the clinic to mitigate some of these challenges. So being survivor-centered means that this decision is made by the minor because as we have talked about, they are the client. Their parent is not the client. Their advocate is not the client. I'm not the client. I'm not telling them what they should be doing. What I'm really doing is giving them the information and the options. And then they're, like I said earlier, they're the boss. They're going to tell me how they want us to proceed. And so with minors, this is important to discuss and let them know. For example, in determining whether, a PPO is right for a specific minor client, we might talk about if the perpetrator is their classmate, maybe it would be better to ask the school to implement a no contact order or to go through the Title IX proceedings at the school if the survivor doesn't want to go to court. Is scary to not only children, even adults. I'm scared to go to court sometimes. So if the survivor is, expressing concerns with having to talk to a judge or seeing the other party over the, I was going to say over the screen because a lot of our court hearings are on Zoom. Maybe it'd be better to have the school handle it rather than the courts and a judge. If the perpetrator is an adult, um, maybe working out different ways to avoid contact with that adult. For example, if the perpetrator is the non-offending parent's dating partner, the parent can implement steps to make sure that dating partner isn't allowed at the house anymore. But well, I guess the easy way would be breaking up with them, but um, there could be other possible options other than a PPO. And I know Brittany had touched on this in some of our beginning slides that minors, um, they face this challenge of, their credibility being um, being used against them. I've seen it happen where respondents are saying that the minor is lying or is making this up to get back at them for, some petty thing. Or maybe the minor has a history of other behavioral issues, getting trouble at school for, I don't know, not doing homework or getting into a fight with someone else. A perpetrator can use that against the minor client in trying to get the court to uh, assess the minor's credibility in filing for this PPO. Another barrier is access to services. Depending on the minor's age, they might not have a phone. Most minors don't have an email. A lot of the work we do, especially with our local court, is online and through email. So that's something that you'll just have to work out with the minor client and their parent. Is it possible to set up in-person meetings, or is it more convenient to do it on Zoom so that the survivor if they're a minor, doesn't have to miss school. Depending on their age, do they have an ability to understand a legal proceeding? I usually try at my first meeting with minors, to gauge like their understanding of the process to see if they can explain it back to me, and that kind of helps figure out, where they're at in terms of being able to understand what this legal process means and what it'll look like for them moving forward.
So Becca kind of just discussed some of the things that we do as a clinic to help mitigate some of those initial barriers that pop up with our minor clients. One she mentioned is how we meet with our clients, and we're very intentional when we're meeting with minors in particular to meet with them one-on-one away from their parent or guardian or whoever has brought them in. because we do want to make sure that they are the ones that want a PPO. They're the ones who want to move forward. It does a lot to help build rapport and trust, that they know that, they can talk to us. And this, we have on the slide here explaining confidentiality. For us, it's also explaining attorney-client privilege and that they can tell me things and I can't tell their guardian unless they give me permission. And so that can kind of open things up in terms of there might be things, like Brittany was talking about earlier, that they were ashamed to tell their parent, or um, that they just didn't want to tell their parent because they didn't want them to worry. And so, meeting with them one on one, whether it's in our office or maybe it's over FaceTime or Zoom or just something, so that we have this communication. And a lot of times I'll, text with my clients because that's an easier way to reach them, something that they do. Our agreements with them, for us, it's a retainer agreement. For an advocate would be, a consent for service. It's very clear and in plain language, and it's for the minor to sign so that they also understand the seriousness of what we're doing. We're filing, legal paperwork, and, they're the ones driving this decision. And so they're the ones that need to consent to it. And so we, write it out. But we also, acknowledge that they're children and they might not want to deal with everything. They might have, a lot of things going on at once. This PPO might be part of one thing, but there's also could be, child protective services talking with them. There could be, a law, they might have to go give a forensic interview. And so it might just be a lot if they're trying also to, focus on school or, whatever their hobbies are. So we also have what's called a designated adult agreement. And so it gives the minors an opportunity to designate a trusted adult as someone that we can talk to about the case, um, instead of on their behalf on occasion. This designated adult agreement also helps the adult involved to know that, again, the minor is the client and we're not going to betray their trust and share things that they haven't authorized us to share. We also need to think when you're working with minors about barriers that pop up with mandated reporting, and confidentiality. Am I explaining that to the minor before they share with me everything that's happened, so that they really understand the boundaries and that, we can build that trust? Like, if you tell me this type of thing, this is what triggers a mandated report. And at that point, by statute, I have to break the confidentiality. And so really discussing that and seeing what that looks like. And then they can choose, they're again in the driver's seat. They can choose what they disclose and what they don't.
Think what my colleagues Kate and Becca have raised regarding rapport building and treatment of youth, and continuing to, at every point, empower and encourage as well as inform the young people that could walk through our doors and become clients, as well as um, some of the information that we talked about earlier with working with identities within Black communities, right, that have a certain circumstance of intergenerational trauma that's to no fault of their own. It's also important to think about, and I know the slide says minor with a minor survivor, but it's important to think about how trauma plays a role in the process of preparing a petition for both populations. When we think of minors, and this could also work with survivors and clients coming from communities of color, it's important to set the tone of your office, right? If you know that, as we've described, that there are barriers in terms of just having an elevated response to trauma as survivors, thinking about, is your office, if you can help it, is it as approachable as what it needs to be? Because it can have everything to do with if your client is comfortable. Are you grounding them with offering them water or tea or whatever? You might even have some great snacks at your agency or organization. But preparing the environment so that the client can be as calm as possible, or either work to regulate in your presence, because ultimately we do need something from them. You know, the relationship still is transactional in the fact that they have this issue, but we're charged with trying to meet them where they are so that we can actually help. So thinking about their nervous system, which also means that you're taking time to make sure that you are working towards their regulation, that you're working towards calming them down. So the tone of your voice might change. You might speak slower. You might spend time talking about other stuff before you even start talking about the incident that brings them in. You could spend that time getting to know them. Even if you have a meeting that's 45 minutes, 5 of those minutes could be used for some regulation skills and for rapport building. So again, thinking about our advocacy, not as cookie cutter, not as doing the same thing that you've done before and just like cranking the documents, cranking the filings out, but making sure you're being trauma informed and appreciating that, you know, someone could have navigated several systems and even transportation issues to get to you, or a child is having to navigate telling on someone that's really important to them, or not knowing how this experience with you is going to change their life, even if it's temporary. So being aware of that and making sure that your environment and your approach as a professional is meeting that reality. And so even when you're thinking about the form, right? We have a lot of forms that we have to fill out specifically for attorneys and legal advocacy. There's always something that has to be filled out by a deadline or given to someone or signed. So sometimes it's important to just come off the form. What do I mean by that? Using your eye contact. You are great at this job already. You know what it takes. So using the experience again to become relatable and to make sure you have higher interaction and you're not just looking down at a piece of paper or looking at a screen on your laptop, but that you are having a conversation with them and being able to then pull details from that. You're going to be more likely to get the information, even if it's hard to talk about for the client. You're going to be more likely to get that information from them if you are more engaged. And I think you think about the intersectionality when I talked about Black women and Black young girls. You think about how so often they might not feel like they have a voice. They might not feel like they are going to be believed. There could be some hesitancy or hesitance around navigating the relationship of law enforcement and the criminal justice system. So you think about in your mind how you're going to come across, being aware of that, but as a person that makes a difference, right? A change agent in how you build that relationship with them. And then because there has to ultimately be a push for the details, explaining that to them. I always find that working with my clients, you know, telling them things like, I could traumatize you because you have a different definition of support than I might have. And I can't be afraid for you to tell me that. And leading with, I'm going to have to ask you a lot of questions that are going to feel really personal and feel really uncomfortable. And the crux of the protection order is to not just give information about what happens, but also to get all the details so that you come alive, you know, off of this piece of paper, so that the survivor story becomes almost like a movie reel for the person reading it, because they have to, again, a reasonable person has to believe that this person's life is in danger, or that they are threatened to such a degree that there has to be this measure put in place. And ultimately we want that success. So explaining all of that to the young people that we serve, to someone that might be reluctant to interact, is going to be very important. That's also going to increase their ability to trust you. It's going to increase their ability to feel safe. And we talked about this before, but again, going back to take more than one meeting if you can help it. You know, use our technology. We have phones, we have FaceTime, there's Zoom. So figuring out how you can get what you need by not trying to just cram it into one setting, or how you can expand that one setting so that it doesn't feel like it's so just heavily focused on them cranking out details in some sort of order like a robot. And then
Yeah.
assure them that there are, oh, go ahead.
I was just gonna say thanks, Brittany, for bringing that into the space, how it is possible for us, as me as a lawyer, you all as advocates, um, to re-traumatize our clients and survivors by yeah, sticking to those forms, just being like, I gotta get this legal work done. And so I think I've heard it on other trainings as well, trying to end my sessions with clients by asking them, like, what are you gonna do after this? So I can learn a little bit about them. And then, I've bonded with people over, like, I have a dog. So I'll be like, oh, I'm going to walk my dog after this. Turns out they have a cat that they like, and they tell me, the silly name of their cat, and we can laugh about that. And that's how we end our call, after we've talked about, this horrible thing that has happened to them, because I'm trying to recognize that I've really only entered into their life because of a trauma that has occurred. And so when they see my name, on their phone, I'm calling them, they might think, oh, I have to talk to Becca about, this horrible thing that happened to me. So that's why, yeah, I do try to bring in that humanity piece that you're talking about, Brittany.
Yeah, thank you for that. I think that's really important. I can't, you're not going to have, and I'm saying but we're not going to have much success in this work, particularly as we're talking about PPOs today in this moment, if, again, as I mentioned earlier, we are just so focused on being the helper, the expert. There's a shared experience of trauma that I've mentioned that we all have. And so this is the moment here when we're considering what role trauma plays, that we think about a time that we've had to ask for help, or even if we're people that don't even like asking for help, that's something that we need to know about ourselves. A half of being trauma informed is also about being aware of your own baggage that you can bring into this field, that you can bring in as an attorney, as a legal advocate, as an advocate in general, right? What stuff do you bring to the table that could be challenging for a client to deal with, to work with? And then that's also a part of your intersectionality. So being mindful, right, of experiences of Black women and Black girls in their community, and what it could look like to even receive help or to trust help in general, and setting the tone and stage for your office, for your meeting with them, how you're going to present, what you're going to say, what you're going to do differently. And then also with children, thinking about their developmental age and what expectations you have and how you might have to change them, not lower them. Notice I didn't say lower, but you might have to change them. That's a part of being survivor centered to get what you both want. There might have to be, and we should be doing this with all clients, but for both populations, you might have to give more of yourself and be able to explain it in a new way than you've previously explained it. And so also I want to highlight for both folks that we've talked about, youth and also Black women and Black girls, let people talk about things in the way that they've learned about them. If they don't have the language, then you listen, and on the back end, you help them talk about it and give it the appropriate language that it might need for the filing or need for them to go to court. And you also explain and prepare to go through this process with them if your job allows you. It's not just about filling out a piece of paper and them talking to them, but looking for experiences to accompany them. And like what Becca was saying, you check on them. And Kate even mentioned letting young people say it in the language that they have is really important. And you also want to do that when someone comes from a different community without judgment and without stigma.
I think, what you're just saying, Brittany, really ties into this end piece of the work product here is a petition, and that, as leaders, we want to make sure that we're having our advocates assist with filing the most successful petitions. And the, overarching goal here is to tell a compelling story. And we can tell our story in a way that bolsters the credibility and kind of mitigate some of the barriers. We talked about youth might experience barriers around credibility, particularly those, that might have been in trouble before or, have some vulnerability that a perpetrator could expose. And so when you're telling your story, you address some of those things and you are honest about things. Brittany's talking about language. If I'm working on a petition for a child, it might be easy as an adult to change the way they describe things to a way that I would say it or that a judge might want to hear it. And then sometimes we do have to do that to make sure the judge understands, what we're trying to say, but we don't have to change all of it, and we can let, the story be told from a child's point of view. And that strengthens their story. And we can include things like, that we might want to leave out, like how they knew the touch was wrong because of, maybe a feeling in their belly or something. Things that might mitigate barriers that come up about why they didn't disclose earlier, threats that were made, just details that offer explanations that might not come out later if they're testifying. They might not remember everything, but if we write a good petition, we put it into the court's records. We've talked about a few times having incidents that a survivor is comfortable talking about. But also we want to have the incidents that fit into a PPO statute. I don't want someone to have to talk about this really traumatic emotional abuse that's gone on when that isn't something that's going to help them ultimately to get a PPO. It might be something to mention to provide a bit of context, but they don't have to go into all the details about that, and we can help them to avoid having to go through that. We also want to consider always that there might be a hearing for this PPO again, what incidents they want to talk about. What is the age of your client? If I have a 10-year-old, they might not be able to testify in court. The judge might not want to hear from them. Is there somebody who could testify that saw something or, just thinking about those kinds of things, um, and, how we can best serve our clients by having them be prepared and letting them know maybe they want to include details that, as a lawyer, I don't really want to put in there, or, as an advocate, you don't think are necessary, but it's important for their story. And ultimately, this is their story. And again, as a survivor-centered law clinic, we always let them choose. So once they understand the risks and benefits of including any of the information, it's ultimately their decision and we put it in. I think to end, we just wanted to go through a couple quick scenarios. First, in the scenarios, we'll look what barriers pop out, what things could we do to mitigate the barriers, and then, discussing, because we've gone into a pretty good detail, what PPO petition would we use and, what sort of details might strengthen the case.
So our first scenario is with Sabrina. And Sabrina comes to you and says she is afraid of her mom's new boyfriend. Sabrina is 15 years old and goes to an alternative education school because she was kicked out of her public school. And so she tells you that her mom has been dating Benny for 5 years. He recently moved in. The mom works nights, so it's just going to be Sabrina and Benny at the house. And about a month ago, Benny started watching movies in the living room that had sex scenes in them. Then one night last week, he came into Sabrina's room, laid in the bed. He said he just wanted to cuddle, but in Sabrina's words, he did more than that. She feels weirded out, but doesn't want to upset her mom. So she has not told her mom yet. And so, Brittany and Kate, if you'll sub in for our listeners out there who can't respond to us right now, what petition would you maybe suggest to this survivor, Sabrina?
I think one of the things that would be important to know is does Benny live there? It sounds like he does. He recently moved in. Um, in which case, then you might use a domestic petition because now they've lived together, they've cohabitated. And the reason we might want to use that is because, again, the lower standard. Um, I think that would probably be the best solution. But if there's, if Benny doesn't really live there, but he stays there, a couple nights a week, that's a different situation. And now you have potentially a non-domestic sexual assault.
So it sounds like there needs to be a further conversation about that and then, about some other things as well.
Yeah, I think from an advocacy perspective, I'd want to know how she feels about Benny. And we talked about that there's a fear, but why, Sabrina, are you afraid of Benny? Have there been other situations that made you feel weirded out? I want her to maybe describe to me the context of their relationship. And I'd also be curious about mom. It says besides just chalking it up to normal teenage secrecy or having this be a situation where obviously she's uncomfortable about something that happened and then maybe just not wanting to talk about it. It could be that there's a strained relationship with mom. And again, going back to in being trauma informed and survivor centered, is there a way that we can identify some support for her after the relationship of, filing the PPO, but also during the process? Who's going to be the support? Who might we be able to get some more details from?
Yeah. I think we had mentioned earlier how minors, they might not feel comfortable telling us right away maybe what happened, or they have, yeah, different language, different use of the language than we might have as adults. So I think here I would probably, ask some follow-up clarification on he did more than just cuddle. What does that mean? What does that look like in Sabrina's words? And giving her the time and space to, feel comfortable telling me that. But I think I would need to know what that incident was, but whether in deciding whether to file for a PPO or not.
Should we take a look at Yvonne?
Yeah.
So Yvonne comes to you with her mom and says that she wants to get a PBO against her child's father. She's a Black high school senior and she just turned 18 last week. And it says she's been dating Elijah for about 2 years. They have a 1-year-old son together. They do have a parenting time order. And it was during parenting time exchange about 2 months ago when Elijah made Yvonne come into the house and assaulted her. She hasn't told the police, but there are, weekly child exchanges, it seems like. And it doesn't seem like Elijah wants to change the location of the meeting. She wants to change it to work. He still wants it to be at his house. What are some of the barriers you guys see that pop up?
I think the first one, again, just in thinking about even safeguards, like I want us to be like protective of our clients sometimes, right? And so we talked a little bit about stereotypes within the Black community, but specifically, Yvonne is someone that doesn't say that or indicate that she's married, and they've they have a son together. She has a little boy that she has to be concerned about. And so thinking about the type of labeling that she could be faced with and how I, as her helper, as the advocate, could work to strengthen her with this truth, if appropriate, if we develop that sort of relationship, but being honest about perception, making sure even that there's something in place for the child when I mentioned childcare earlier. So thinking about that and even what it means for her to disclose against the partner if he is of the same race, bringing back again racial loyalty to a fault. Like, how is she going to believe? How is she going to be perceived? Does she have challenges around talking about this? Does she define it as violence? What type of feelings is she having? And also, is she allowing herself space to breathe and kind of reset? Does she feel like she has that space, or is it a luxury for her? Those are all the things that come to mind first, which is typically how I approach even before, doing the work, whatever that is with a client, is thinking about what kind of space that they're in, and how I might have to address that first, addressing the trauma as the priority.
Yeah, and somebody who, I mean, I think the scenario was she just turned 18. Someone who's a fresh adult, is someone, who it sounds like was I think a child when her son was born. So someone who's kind of balancing this line of was still in high school, but moving into adulthood, having a child, adding to that. And so I think kind of seeing where she's at with things, what's her priorities? Is finishing high school the top priority? Well, then maybe, engaging with the court system might not be helpful to that. But if, there's these safety concerns, then working out what is the best option. Um, Kind of wondering here, does Elijah go to that same school? Is there something we can get with the school? Um, Seems like they have a court order. My mind, the cogs are turning in my mind. So if there's already a court order, is it maybe easier to file something in that court instead of uh, filing for a separate PPO? Um,
Yeah, I think similar to Sabrina in our last scenario, it says Yvonne comes to us with her mom. So being curious about what that relationship is and imagining, like we've already raised here, for most young people, senior year is important. Not every high school senior wants to go to prom, but there's a certain amount of weight and excitement that comes with graduating. And of course, also being mindful that there are stereotypes around Black communities in education. So being careful, as Becca mentioned, to prioritize that if that is important, and being willing to, again, be creative about how it could look with a graduating senior and wanting to gain voice or have some sense of safety through the use of a protection order. And so that is also why I would be interested in mom to see how much support she already has, or if there's support in someone at the school that could be useful to see her through, along with advocacy support from the agency or organization.
I think one of the barriers that Yvonne will face is that she had a prior dating relationship with Elijah and consensual sex or, sexual contact. And so being sure to emphasize what's different about this contact than other one, sometimes um, there's a stereotype and it's difficult to prove that it was non-consensual when people have had sex before. And also kind of asking about what things look like. Like, was this the only time when things were forced? Um, and just having those discussions, possibly over time.
And then similarly to what we've been pulling out to you, but particularly in the scenarios, it's important to get clarity. Again, letting our clients, allowing them to speak in their own language as individuals. But when it says, force me to have sex, right? Getting more clarity on what that actually looked like, and getting clarity on and what those feelings were while the event was taking place. So being careful that to ask good questions and to get as much specificity as possible when we're working with our survivors, because sometimes if we have folks that are reluctant to express their emotions, that is the piece that could tip the protection order into being granted, because then it becomes even more clear why this was such a grave situation for the person.
I think we've been talking about PPO, so I'll tie it back in. If Yvonne decided she did want to go forward with the PPO, because she has a child in common with Elijah and they previously dated, or maybe are still dating. We don't know if they're on or off right now. Um, you would file a domestic PPO. One thing to keep in mind is that because there's a parenting time order, Michigan has a rule, one judge, one family. So the case would likely go in front of the same judge that is dealing with their parenting time. That can be a good thing, that can cause a little disruption in the case. It really depends. So just keeping that in mind. And also just remembering she has a court order. And so what can you do to increase safety if today is Thursday night and she's meant to be there tomorrow morning and there's no way you can get a PPO in the time? Um, Anything else you guys want to add?
I think the last thing that I want to say, just in general, when we're thinking, so we've presented the all of these barriers, right? All these situations that we're charged with having empathy for, and you've got a strong foundation of what it actually means to file a PPO, the different elements of a PPO, and then we've given you a situation of what those elements look like with the barriers, with the scenarios. And so then it's up to us to think about, even beyond that, how we use our peers, our coworkers in professional spaces to also mitigate barriers. And we're fortunate enough, the three of us, and there's other folks in our office, but the three of us do our best to work together, knowing that these barriers exist. And it's not that we just sit around and list barriers every workday, but it's something that's ingrained in us, right? By now we it's like, you know, it's a very natural process, but we use one another. So if someone has a nervousness, and we've described this already, if we know that the legal system, lawyers, that whole thing is nerve-wracking, then an advocate can be used, if you have both of those, to deal with the more emotional piece of it, to get all of that venting and things that attorneys sometimes actually don't have the time to carry, or have the emotional labor to experience. You use your coworkers to develop a wraparound of protection around the client. So in your agencies and organizations, especially if you are a stakeholder, a decision maker, an ED, be mindful of how you can build a structure to support these barriers, because that's also a part of a space like this where there's collaborative learning. We're sharing for information, but hopefully sharing so there are things that you can take back and implement, or learn how to implement. And the work that we do at our clinic, we're fortunate enough again to be able to structure some wraparound services for that type of support.
So speaking of the clinic, you can contact us at this email below, slc@mcedsv.org. We're always happy to talk about challenges and cases. We take on cases. Our funding is specifically related to sexual violence. So if you have a case that you think might be good for the clinic, you can always reach out. And we
Thank
just want to
you.
thank you. Yeah, thanks for listening to us.
Yeah, we hope this is helpful in you providing information and services to survivors. And we appreciate your commitment to survivors and your dedication to ensuring that your services continue to evolve in ways that are meaningful, effective, and survivor centered.